Everyone is asking whether Donald Trump can find new lawyers in time. That is the wrong question. Here is the real question. Why exactly did Judge Rebecca Caldwell cite Rule 1.7, Rule 1.9, and Rule 3.4? All three ethics rules were mentioned in the same single order. The answers are hidden in yesterday's filing. Specifically, page 34 changes the entire story. This isn't just a simple scheduling problem. This is not just about finding replacements. When a federal judge invokes three separate professional ethics rules to remove an entire defense team, not one lawyer, not two, but the full team, that is not just a disqualification. That is a statement. I found which specific rules matter most, but first, notice something very weird about the timing on this. Quick context. Judge Rebecca Caldwell, Federal District Court, Southern District of New York, appointed in 2019, is known for running a very tight docket. No theatrics and no extensions without significant cause. The issue yesterday morning was that Judge Caldwell issued an order disqualifying Trump's entire legal defense team from the federal fraud and racketeering case. Every attorney of record is now gone. Timeline fast version, Friday, February 6th, the defense team filed a motion to delay depositions. It looked like routine stuff, or so it seemed. Monday, February 9th, prosecutors responded with a sealed exhibit consisting of 47 pages. Nobody saw it coming. Yesterday, Tuesday, February 10th, Judge Caldwell dropped a 19-page order that disqualified all 5 defense attorneys, effective immediately. In just 3 days, the full legal team was wiped out. However, the documents say something else entirely. Check this. The evidence in the first document filed yesterday, the order itself, page 7, states, the court finds that defense counsel's simultaneous representation of co-subjects in the parallel investigation creates an irreconcilable conflict under Rule 1.7. That is interesting, but page 14 is different. According to court documents, Judge Caldwell identified what she called a pattern of informational cross-contamination between Trump's attorneys and witnesses scheduled for deposition. Do you see the problem? Rule 1.7 is about conflicts of interest representing competing parties. Rule 3.4, which she cited on page 16, is about obstructing access to evidence. Those are two completely different categories of professional misconduct. You do not usually see both in the same disqualification order. One means your lawyers have divided loyalties. The other means your lawyers are interfering with the case itself. Judge Caldwell found both in the same team at the very same time. It gets even weirder. I found a third element from the prosecutor's sealed exhibit, portions of which were unsealed yesterday afternoon. Newly surfaced records show that at least 2 of Trump's attorneys had private communications with 3 witnesses on the government's list. There were 23 emails between October and January. Put all 3 together: conflict of interest across co-subjects, evidence of witness contact that was not disclosed, and informational sharing that compromised the deposition strategy. Now, here is what nobody is talking about. The order does not just remove the lawyers. On page 18, Judge Caldwell imposed a 60-day cooling period. No new attorney can access case materials for 60 days after substitution to prevent what she called tainted strategic continuity. Why would she structure it that way? Trump has no legal representation in this federal case as of yesterday. The 60-day clock means any new team starts functionally blind, and 3 scheduled depositions are still on the calendar. That is just the disqualification itself. What triggered it? I'm coming back to that. Pause here and check your understanding. 3 ethics rules in one order: simultaneous conflicts, witness contact, and evidence obstruction. Do you think you know why the 60-day freeze matters most? Comment it, then keep watching. Tuesday, 9:14 a.m. Eastern. Here is what happened. Judge Caldwell convened an emergency status conference with both sides present. No cameras were allowed in federal court. Official filings reveal she opened with this: the court has completed its review of the materials submitted under seal. Counsel for the defense will not be continuing in this matter. That was not a question or a warning. It was a done deal. Immediate consequences followed. All 5 defense attorneys were ordered to cease work. Case materials were placed under a judicial hold. 3 depositions scheduled for February 19th, 20th, and 21st are not postponed. In 72 hours of filings, the full legal team was erased. That is the public version. The private version is different. According to two sources familiar with the proceedings, defense counsel attempted to argue for a partial disqualification, removing 2 attorneys but keeping 3. Judge Caldwell rejected it in under 4 minutes. Publicly, the full team was disqualified based on documented conflicts. Privately, the defense tried to negotiate, but the judge did not negotiate. Then the response came. Lead defense attorney Martin Price filed a notice of appeal within 3 hours. But here is the thing. Based on public disclosures, the appeal challenges the disqualification process, not the underlying findings. That distinction matters greatly. Price isn't saying the conflicts don't exist. He is saying the judge moved too fast. Judge Caldwell anticipated it. Her order included a preemptive finding that delay would prejudice the government's case. Footnote 11 contains 4 paragraphs citing 3 prior cases where disqualification was upheld on appeal under similar circumstances. It was not reactive. It was planned. This is where experts started paying attention. But look, fair is fair. The other side has a case, a real one. Trump's allies and legal defenders argue this is judicial overreach. They argue that Judge Caldwell weaponized ethics rules to strip a defendant of his chosen counsel in the middle of active litigation, and some of it holds up. Their evidence. First, the timing. Disqualifying an entire team 8 days before scheduled depositions creates enormous pressure. Defense attorneys have a right to represent their client, and courts generally disfavor disqualification because it punishes the client for the lawyer's conduct. Second, there is limited precedent for the 60-day cooling period blocking new counsel from accessing materials that long. The freeze effectively paralyzes Trump's defense during a critical pretrial window. Todd Blanche, a former Trump defense attorney and legal commentator, stated, "This order doesn't protect the process, it cripples the defense." Now, here is where their argument falls apart. What they are not mentioning are the 23 undisclosed emails between defense attorneys and government witnesses. This is not alleged. It is documented. Prosecutors submitted them with metadata, timestamps, and recipient confirmations. Rule 1.7 conflicts are not optional when a lawyer represents one client while simultaneously advising a co-subject who may have adverse interests. The American Bar Association's formal opinion is unambiguous. Even Jonathan Turley, a George Washington University law professor and frequent Trump defender, noted, "The factual basis in this order is unusually detailed." That's not a judge reaching for a reason. That's a judge building an appeal-proof record. Both sides have documents and both have arguments. The difference is that the defense is challenging the procedure while the prosecution provided evidence of conduct. Procedure arguments are about how things were done, while conduct evidence is about what actually happened. That gap matters. Judge Caldwell did not just cite rules. She cited the specific emails, the specific dates, and the specific witnesses contacted. Pages 9 through 13 include names, dates, and subject lines. One more thing. If the conflicts did not exist, why did Price appeal on procedural grounds instead of factual ones? You challenge facts when facts are on your side. You challenge the process when they are not. Coming back to why those emails exist. First context, step back. How did we get here? This did not start last week. In late 2025, Trump's legal team consolidated 5 attorneys handling the federal case simultaneously while advising on related state matters and a parallel congressional inquiry. In January 2026, prosecutors flagged potential conflicts in a sealed motion. Judge Caldwell ordered an in-camera review, meaning she looked at evidence privately before either side could argue. In early February, the sealed exhibit landed with 47 pages. Things accelerated. Someone warned them on the record. We raised the conflict issue in November. Defense counsel assured the court there were adequate screening procedures. That is from the transcript of a November 14th status conference. Defense counsel said they had internal walls and ethical screens between attorneys handling different matters. Prosecutors said those walls had holes. The pattern is that every time prosecutors flag an issue, the defense assures the court it is handled. Documents later show it was not. It always worked until Tuesday. What changed? The sealed exhibit filed Monday contained emails prosecutors obtained through a third-party subpoena. The defense did not even know they existed. This story is moving fast. Trump's team has until February 20th to file for an emergency stay. Depositions are still scheduled for the 19th through the 21st. Subscribe, and I will cover every filing as it drops. Okay, second layer of evidence, different angle entirely. The 23 emails everyone is focused on. That is the headline. But the sealed exhibit contained something else. Verified financial records indicate that two of the disqualified attorneys, Price and co-counsel Diana Montrose, were simultaneously billing Trump's legal defense fund and providing advisory services to a corporate entity linked to a co-subject in the same investigation. This is not alleged. It is documented billing records obtained through subpoena. Hold on, that is not even the weird part. The corporate entity, registered in Delaware and formed in September 2025, lists a registered agent who also appears as a witness on the government's disclosure list. The same person is a witness for the prosecution receiving legal advisory services from Trump's own defense attorneys. Do you see the problem? According to court documents, the billing records show 14 separate invoices between October 2025 and January 2026, totaling $218,000. That money moved from the legal defense fund through the attorney's firm to advisory work benefiting someone scheduled to testify against their own client. This is not just a conflict of interest. This is a financial pipeline between the defense and a government witness. The emails are bad, but the money trail is worse. Judge Caldwell addressed this directly on page 15. The court is particularly troubled by the financial entanglements between defense counsel and individuals whose testimony may prove adverse to the defendant. Such arrangements undermine the foundational attorney-client relationship and compromise the integrity of these proceedings. Cross-reference this with the Delaware corporate filing. The formation date was September 12, 2025, 3 weeks after Trump's defense team was formally constituted. That timeline is not a coincidence. That is a sequence. But here's what is interesting. What do professionals say? Former federal prosecutor Andrew Weissman, with over 20 years of DOJ experience, said, "This is one of the most comprehensive disqualification orders I've seen in federal practice." Translation: judges usually remove one attorney, maybe two. Removing 5 at once with a cooling period while citing 3 separate ethics rules is almost unheard of. Criminal defense attorney Caroline Polisi noted, "The 60-day freeze is the real weapon here. It doesn't just change counsel. It resets the entire defense strategy." The key word is resets. Whatever work was done over 5 months, motions, strategy memos, witness preparation, new counsel cannot touch any of it for 2 months. New counsel starts from zero. But here is what is interesting. Former Assistant U.S. Attorney Harry Littman said, even if you disagree with the scope of the order, the evidentiary record Judge Caldwell compiled makes reversal on appeal extremely difficult. When a former federal prosecutor says the appeal is an uphill climb, and he is not someone who cheers these things on, that is significant. Forensic accountant and former SEC investigator James Koutoulas added that the billing trail between defense counsel and a government witness, if it holds up, is not just an ethics violation. It is potentially criminal conduct. That word, criminal, matters. We are not there yet, but the door is open now. What this means for regular people: thought we were done with evidence. Then this morning, a new motion hit the docket, filed by prosecutors, partially sealed. What is in it? I have read the public portions, and it changes the trajectory of this entire case. Subscribe, as I am about to show you exactly where this goes next. Wednesday, this morning, 7:40 a.m. Eastern. Prosecutors filed a supplemental motion, partially sealed, but the public portion runs 17 pages. Based on public disclosures, the government is now asking Judge Caldwell to refer the conduct of attorneys Price and Montrose to the Bar Disciplinary Committee and to the U.S. Attorney's Office for potential criminal investigation. It is not the same thing as charging them, but it is the step right before the step. The government respectfully submits that the conduct documented in Exhibit 14 through Exhibit 19 warrants referral for further investigation beyond the scope of this proceeding, says page 4 of this morning's filing. Careful language, but pointed. Immediate fallout. Price and Montrose now face potential bar complaints on top of disqualification. The criminal referral language means prosecutors believe there is enough to investigate, not just sanction. Any attorney considering joining Trump's defense team now has to weigh whether they are walking into a case where the previous lawyers are themselves under investigation. That last point is a quiet bomb, and it gets worse. This morning's filing revealed prosecutors identified 2 additional witnesses contacted by defense counsel. Beyond the 3 already documented, that makes 5 government witnesses total in undisclosed communication with the opposing legal team. Legal analysts are saying that is not a conflict of interest problem anymore. That is potential obstruction. Judge Caldwell has not ruled yet, but she scheduled a hearing for Friday, February 13th, 2 days from now. And here is the part that connects everything. If she grants the criminal referral, new defense counsel won't just start cold on strategy. They will start under a cloud where the previous team's work product may itself become evidence. That is not a reset. That is a contamination problem. Why this matters to you is not abstract. There is real impact. If you pay taxes, listen up. Trump's legal defense fund, drawn from political donations, has been paying attorneys who were simultaneously billing for work that benefited a government witness. That is donor money. $218,000 documented so far. If you donated to any affiliated political action committee since September 2025, your money may have flowed through this pipeline. Here is what some donors are already doing: requesting expenditure disclosures from the PAC. FEC filings are public and quarterly reports are searchable. This is not advice, but it is a pattern I am seeing. This also sets a rule. Next time any high-profile defendant runs a consolidated legal team across multiple related cases, it's a different game. Judge Caldwell's order, if upheld, becomes a roadmap for prosecutors to challenge multi-case defense teams. If you are a business owner and you hire one law firm to handle a civil lawsuit and a regulatory investigation simultaneously, and those matters overlap, your lawyers now face heightened scrutiny under the standard Caldwell just established. That means legal costs go up. Separate counsel for separate matters means more attorneys and more billing. That cost trickles down to every client at every firm watching this case. Legal professionals tracking this say firms are already reviewing conflict check procedures nationwide. The National Law Journal reported at 3 a.m. that Law 100 firms issued internal memos about the Caldwell order within hours. Nobody wants to say this, but if your attorney has ever represented multiple clients in related matters, and most large firms do this regularly, the Caldwell standard raises the bar for adequate ethical screening. Here is what informed people are doing right now, checking whether their own legal counsel has potential conflicts, requesting written conflict check confirmations, and asking their lawyers directly, are you representing anyone with interests adverse to mine in any related proceeding? That third question is the one most people never ask. After this ruling, it should be your first. There is yet one more layer. If Trump cannot seat a new legal team for 60 days and depositions proceed next week, any testimony given without defense counsel shapes the trial. Prosecutors get testimony on the record while the defense responds later with new lawyers who were not in the room. That gap has real consequences in federal court. Now, how the other side responded. Trump's response made it worse. Within hours of yesterday's order, a statement posted on Truth Social called Judge Caldwell a partisan hack appointed to destroy, and described the disqualification as the most corrupt judicial act in American history. Quote, "They can't beat us in court, so they remove our lawyers. This is a dictatorship." The post hit over 11 million views in 14 hours. Legal commentators noted attacking the judge mid-ruling could affect future motions for recusal or venue change negatively. The prosecutor's response was one line in this morning's filing. The defendant's public statements speak for themselves. Then things escalated. Republican members of the House Judiciary Committee announced hearings on judicial overreach in politically sensitive cases. Subpoenas for court administrative records were threatened, though legal scholars noted congressional subpoena power does not extend to active federal judicial proceedings. Meanwhile, Trump's political operation launched a fundraising email centered on the disqualification with the subject line, "They took my lawyers." It generated $4.7 million in small dollar donations within 18 hours. A legal setback became a fundraising event. A court order became content. Disqualification became a campaign moment. That is the cycle. The legal system acts, and the political system monetizes it. Repeat, if this breakdown is useful, subscribe. If not, don't. Friday's hearing is the next major development. I will have the filing analyzed the same day. What we don't know yet: 1. What is in the sealed portions of this morning's motion? 17 pages are public, but the full filing was 31. 14 pages remain sealed. 2. Whether Price and Montrose cooperate with a Barr investigation or fight it. The response deadline is February 18th, scheduled February 13th, hearing on prosecutor's referral motion. February 18th, defense response deadline for Barr referral. February 19th through 21st, depositions still on the calendar with no postponement. Trump's team is reportedly interviewing replacement counsel. 3 names are circulating, but none are confirmed. The date that matters is February 13th, Friday. If Judge Caldwell grants the criminal referral, this stops being a defense problem. It becomes a case where the lawyers themselves need lawyers. Where things stand right now, Trump has 0 legal representation in the federal fraud and racketeering case. 5 former defense attorneys are disqualified, with 2 facing potential criminal referral. The 60-day cooling period means new counsel cannot access materials until mid-April. 3 depositions remain scheduled for next week. February 13th is the hearing on criminal referral and Barr complaints. February 18th is the deadline for disqualified attorneys to respond. February 19th through 21st, depositions proceed. Not public yet. 14 sealed pages. Judge Caldwell decides Friday whether any get unsealed. The clock is running. The appeal Price filed is on an expedited track, but no ruling is expected before March. One more thing before we close. That is what the documents show. It is not my opinion and not my spin. It is Judge Caldwell's order, pages 7, 14, 15, and 18. It is the prosecutor's sealed exhibit portions unsealed yesterday. It is this morning's supplemental motion, pages 1 through 17. Billing records, Delaware corporate filings, email metadata with timestamps, all public, all linked below. Check it for yourself. When Friday's hearing happens, I will have the transcript analyzed. When the sealed pages get unsealed, if they do, I will read every word. This case just shifted not because of politics or opinion, but because a federal judge looked at documented evidence, emails, billing records, financial transfers, and concluded that the most basic duty a lawyer owes a client had been violated. That is not partisan. That is procedural, and the procedure has consequences that reach far beyond one defendant. Subscribe if that's useful. Documents in hand.